Was it? Okay, was this meeting properly noticed?
Yes, it was.
Roll call vote. I'm Barb Morgan. I am the chair of this committee, Supervisor, District 6.
Rocky Gilner, District 2, Vice Chair.
Larry
Quick,
Baru,
District 5.
Larry Baru, District 4.
Chuck, we didn't get you.
Chuck Quick, District 5.
Jody Shapey, District 7.
Randy Thiessen, Citizens Member.
I think we got everybody. We know that Bruce is, can be excused if he couldn't get on with us. Okay, we need a motion to approve the agenda.
So moved, Rocky.
A
Second. Second, Larry.
All in favor, say aye.
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 Opposed? We have an agenda. We need a motion to approve the previous minutes, meetings minutes.
Chuck Quick, move to approve minutes.
We need a second.
Second, Rocky Gilner.
We have a motion and a second to approve the minutes from the last meeting. All in favor? Say
Aye.
Aye.
Opposed?
Aye.
While we go on, surveyor's report. Are you on, Jerry?
Jerry was having access issues. The report should have been connected to the agenda.
It wasn't though. Yeah,
It was not.
no.
All right. Well, I will, it's very short. I will get that out to everybody though.
All right. We'll go on then. Register of Deeds office. She said, sent us an email that she's out and there was nothing to report. So land information. We'll go into the public hearings. Dusty?
Gotta get to the notes. The only application is for Adams Friendship Area Schools, Grand Marsh School, Agent Olson Farms. Reopen a tabled conditional use request under 40532C of the Adams County Comprehensive Zoning Ordinance to allow seasonal agricultural labor housing on property located in the northeast quarter, Section 7, Township 16 North, Range 7 East, Town of Newchester, Adams County, Wisconsin, 620 County Road E. I believe court counsel is on the line. I don't know if they want
Yeah.
to.
If the chair would permit me, I'd like to interject quick.
All
Um,
right, go ahead.
Thank you. Just a quick recap there. This had been part of a tabled motion back in November with a two-part sort of an application here. There was a rezone and a conditional use permit, as the committee remembers. Tabled for the rezone to work its way through the process. We had ultimately seen it approved by the county board. However, the town ultimately vetoed it, so to speak, after the fact. So it did not become effective. Therefore, the zoning has not changed. The rezone has not occurred, or the zoning remains as it had at the time that this motion was tabled. So we're still under that original PSP zoning. With that, the PSP zoning, or the reason for the CUP here with the rezone was that you'd require the rezone to A3 to allow for the proposed use in the CUP. So without that rezone, we're still under PSP zoning, which does not make a conditional use or make the proposed use here a conditional use. Therefore, court would likely find that even if the committee today approved of this CUP, because there isn't proper underlying zoning, rezoning, or underlying zoning based on a rezone, it would find it void.
Thank you. Dusty, did you have something more?
You're muted, Dusty.
Dusty, you're muted.
Yes, I am. Attorney Rawlings, we would still need to do the full public hearing, correct?
Right now, we're on a public hearing.
I'm sorry, taking public participation as part of the public hearing, correct?
I believe we did not, I think we entered that as, since there had not been public participation in the past, you can go ahead with public participation now.
Okay. I did receive 2 items recently. Most everything was attached to the course or to the agenda. We did receive a letter from MS Real Estate Holdings. Dear Adams County Planning and Zoning Department, MS Real Estate Holdings LLC is in receipt of your letter dated January 18th, 2022 regarding the Adams Friendship Area Grand Marsh School Agent Alston Farms conditional use request. As a property owner within 300 feet of the request, we are writing to notify the Planning and Zoning Department of our approval relating to this matter. We did also receive from the Highway Department, thank you for your opportunity to comment on the Grand Marsh School conditional use permit. The Adams County Highway Department has no concerns with the Grand Marsh School conditional use request. I did also receive a phone call from an adjacent neighbor, and that was Larry Cole. He is against the application. And that was all the additional correspondence.
I see somebody had a posting up that they wanted to talk.
Thank you, Dusty. Now we'll go into, is there someone representing Alston Farms that would like to speak?
Yes, this is Megan Wallendahl representing Alston Farms. We also have Larry Alsum and Lee Turini on the call as well to address this matter. We felt it was still important to come before the board and state our case and would like to argue our stance on it. I don't know if Lee, if you've got anything you'd like to add.
Yes, good afternoon. I assume you can hear me.
Yes.
Okay, thank you. My name's Lee Turoni. I'm an attorney for the Dempsey Law Firm that represents Alston Farms. I've been following this issue. And just to recap how this issue has gone, and this will be brief, folks. I'll only take a few minutes. I mean, 2 or 3, okay? The zoning change hearing happened and there was not an effective certified resolution by the town in opposition to that. And the result of it eventually was that the committee recommended adoption of the ordinance as is. Now that went to the county board and there was still not an effective veto by the town present at that time, as the town of Newchester. And the county board voted to enact ordinance number 52, which approved the zoning change that was applied for according to the petition. There was no changes to it. Now in the statute, it's 59.69, sub 5, sub E, number 6. And I quote, "A ordinance submitted like that shall become effective on passage." So if there's not been an effective disapproval prior to the county vote, when the county votes on it, that ordinance becomes effective upon passage. That means that the zoning change took effect whenever that occurred. It was a month or 2 ago. Now, the 40-day veto, which was attempted, and I'm not the town's attorney, so I didn't advise them on that. But there is no 40-day veto opportunity if you don't have the effective 10-day disapproval. And there's a court case exactly on point on that issue. It's called Johnson versus Washburn County. And I won't provide a further citation because I provided it to the county's attorneys in advance. And that court case was exactly on this point, that if you don't have a 10-day disapproval, you can't do a 40-day veto. Now, if you look at that statute, the reason why is because it's like a choose your own adventure type of statute. Depending on what the committee result is how the potential ordinance proceeds through the administrative process of the county. Because that didn't happen, and it was just a proposed ordinance without a disapproval, when the county board adopted it, it was enacted. In the same subsection I mentioned, it says the county clerk shall submit a copy of any other amendatory ordinance to the process where you can have a potential 40-day option for a veto by a town. Any other means, as opposed to the beginning of the same section, any other version than one that just skated through. Okay, which is essentially what happened here. So the zone change, I think the statute reads plainly, and I think the case law is directly on point. It reads very clear that the zoning change already happened. And therefore the CUP application is eligible to be made. It was made originally. It was just tabled for the convenience of the county as the issues got worked through, but it was requested to be off the table because the zone change is already in effect and the applicant followed the law. And an applicant that follows the law gets a fair chance for a hearing. That doesn't take the decision away from the county at all. It's still totally yours. But an applicant that follows the law to make an application gets to have a hearing. And so that's why it's on the agenda today. And we're prepared to have that hearing. Thank you.
Dusty, do you have anything to add?
If there are no other public comments, I would like to respond and correct a few points that Mr. Taroni just added.
We're just taking committee and our attorney comments right now.
That's who that was.
Yep. So I'm
Okay,
your attorney.
all right.
So, anyway, so so the issue here turns on whether or not, as Mr. Taroni said, this was effective or ineffective on the town's certified notice of disapproval. County's position is that it was effective, and therefore legally as it would be today, there'd been no successful valid rezoning despite the county's approval, because within that 40-day period that Mr. Taroni mentioned, the town then again filed that certified notice of disapproval. So that's how it is today.
This is Jody Shapey. May I ask a question?
Yes, go ahead, Jody.
Mr. Rowling, my understanding is that the 10-day disagreement was filed appropriately, and then the town of Newchester also followed that up with a 40-day. The attorney Tarini is saying otherwise. Could you enlighten us on that?
Sure. So the 10-day period after the committee hearing last time allows for the town to file a certified notice of a resolution disapproving this. From what I understand from Attorney Tarini's correspondence, their objection is that the town's resolution referenced the petition, but did not attach that petition, though it said it would be attached. County's position after review was that it still remains effective, even considering the Johnson case that Taroni mentioned, and even considering a few more cases from prior iterations of the statute. So the county's position was that despite that challenge or despite that objection, that town veto, if you will, was still effective at that stage.
Thank you.
Are there any more questions on the committee level?
This is Jody again. Could I just say one more thing?
Yes, Jody.
The way that the agenda was written did not specify that this was a public hearing. And from everything I've understood, this was to be a formality. I would assume that there would be more people on if they had been aware that there was the potential for a public hearing.
It says public hearing on our agenda.
Hold on. Let me just get back in there.
And then I know that the people were notified by mail that live there around.
And it was also published separately for 2 consecutive weeks, with the last publication being 7 days prior to today as
Okay.
a public hearing.
When people called in, Dustin, were they told that this was a formality?
I explained to him what the county's position was and that the committee had to deal with, or had to handle the conditional use request, and there is a public hearing still.
Okay, thank you. I do see public hearing after the number, but not within the body of the thing. So thank you.
All right, Megan, you had something more to say?
Sorry, I had to find my unmute button. I just wanted to reiterate about our project that we feel like this was not given a fair accounting by, I guess, County Board and Corp Council. Some of that is, I think, reflects on the values of the county board, which is that we conduct our affairs in a professional and accountable manner that's resourceful and credible. I don't know if we've truly followed that. And we've had over 120 signatures and letters of support, and don't feel like we were addressed. Our concerns were addressed about that resolution appropriately. I don't know if Lee, if you have anything else to add.
Just real briefly, the defective resolution by the town, when they sent one in, it did not identify the petition at all, except to say as attached. Now, we requested a copy of that from the town, the county, from the county's attorney, and not one single copy had an attachment. There's no way to verify what that was meant to do in a legal sense. You have to understand that that's creating the record for review. And the case that I mentioned is extremely specific, that the law has to be followed to the letter in order for any veto to be effective. And that's that opinion. This is not an ambush for the county. I've been giving correspondence to the Corp councils this entire time to advise them of our position. This is kind of an ambush on us to hear for the first time now that people didn't intend to proceed. I don't think that's very fair and could be a due process issue. The applicant followed the law. They have an application before a body to be heard. And that's kind of how it works. Now, the result remains up to the body, but the fact that you can't even be heard if you follow the law and file a petition, that's very unusual. So that's it.
I'll just comment briefly that we are having a hearing right now on this petition. And this is a retabled, or this is coming up from the tabled zoning or the tabled CUP application.
We can only have a hearing if the zoning change happened. So which one is it?
If the zoning change did not, it was approved, like I said, I can reiterate again, it was approved, 40-day period rendered ineffective. So we're still on the tabled, and Chair, I don't want to usurp your points right here, but it was a tabled motion or a tabled application on the CUP. Rezone was going through to the board first before they came back to the CUP.
Is there anyone else from the committee that would like to speak right now or ask any questions? All right, we'll open it up to the public. If you're out there and want to speak, you have to state your name, address, and you have 3 minutes. And Dusty, I hope you've got a timer. Do we have somebody that wants to speak? The public?
Hello, this is Bill McChesney speaking. I reside at 2552 County E, Grand Marsh. And I'd just like to state we, as a town, we filed a certified resolution and we had a veto that we sent in. I just want to know if this is this conditional use is gonna go through, or is it not gonna go through because they didn't have a proper zoning approval?
We'll let our attorneys, one of them speak, please, to answer Bill's question.
The CUP is currently up for vote. So we'll have to see whether it's approved or not. We've discussed already, but we've talked about the CUP. So it's to be decided.
So does the conditional use request have to come back to the township? Or it's decided upon lawyers? Or how does this work? I just want to know.
The CUP was tabled, like we've discussed already, the CUP was tabled at that prior meeting. And the CUP is now being heard again. It was tabled to allow for the zoning process to go through and be considered. And it's being heard again because the zoning process has happened already. The zoning has been considered.
Because there's conditions to the conditional use, isn't there? That need to be heard if this is open. That were addressed at our town meeting. And
So-
like at our town board meeting, we had conditional use of how many people may be housed in this location. And those are all conditions, aren't they?
So I can say
Yep.
that we, go ahead.
Yes, Bill, and I've got that copy.
May I ask a question? This is Jody Shapey.
Yes,
Attorney Rowling, we're saying that the rezone did not occur.
Correct.
So when we're looking at a cup that's just hanging out there, not connected to a rezone that didn't occur, what is the normal process?
You're saying like
You can't have one without the other is what I'm saying. Is that correct?
you need to have the underlying zoning allow for that conditional use. So you can request that condition, you can request the permit for a conditional use, but the underlying zoning has to support that.
And
Here,
it does, correct?
excuse me, I'm sorry, I spoke over you.
It does not pertain to the current zoning.
Currently,
you
the-
PSP zoning, because the other did not go through.
currently the current zoning, the PSP zoning does not allow for that conditional use.
Thank you.
so, JR, are we supposed to, because the other thing, she said the rezoning didn't occur. What do we do now? I don't, I'm mixed, I've got a mixed message here.
You still vote on the CUP. You've heard what I've said about it being likely considered void or invalid if it were to be approved by you. So our recommendation is that it's considering that even if you were to approve, a court would likely find it invalid because the underlying zoning did not go through and you're under PSP zoning and the PSP does not have the intended use as a conditional use.
Have you been listening, Bruce?
I just got on. I had the passcode for the March meeting was in the email. I'm sorry.
Okay.
Barb, this is Rocky.
Yes,
Back when we did this the first time and set up all the conditions, did we actually have a motion and a second before we tabled it?
no,
Okay.
I don't believe, this is Randy, I don't believe we even heard any of the conditions that the town asked for at that meeting.
no, I don't think we did anything with conditions. We just tabled it because we had to wait, we wanted to wait to see if the zoning went through.
Randy again. I'm wondering if we should just vote on this and let the lawyers figure out if the rezoning was valid or not.
I would jump in to say you should continue taking comments from any of the public that is present.
Absolutely.
So there is a complete public hearing record.
Yeah.
It
And
sounds
here's
like
the
there's some
condition.
late, it sounds like there's somebody that wants on, they have to state their name and address.
My name is Wendy Logic. Can you hear me?
Yes,
I live at 2757 County Road G, Oxford 53952. And you can hear me okay?
yes, we can.
Okay, I have an issue with this. I don't want this to be passed as far as Elsom Farms using the Grand Marsh Elementary School for housing. I think that 80 people almost doubles the population with just one community forever changes the structure of a town. This is not the way to change zoning. Change zoning, you do it to benefit the community. This does not. Only ones to gain are Elsom Farms. If this was Portage or Wausau, that would be okay. Corn and Tater Fest would become something else. God pray you make the right decision. And also, I think this meeting should not have been it shouldn't have been a Zoom meeting. It should have been held where we could have been there, because a lot of people don't know how to use this Zoom. So, but that's all I have to say.
Thank you, Wendy. Is there someone else that would like to speak? Paisley. Is there someone else that would like to speak?
Barb, am I able to make a comment back at all?
Yes,
And this is Megan Wallendaw with Alsam Farms. Do you want me to state my address?
somebody just came in the yard. Go ahead, Megan. I'm gonna go on mute.
Committee, did you want me to state my address?
If you're speaking as the applicant, you would not need to. If you're speaking as a citizen, then yes.
No, as the applicant, I just would like to remind the committee, we did have a economic poll. We do have the support of every single business owner in Grand Marsh. We did an economic poll with our crew and what they currently spend at a gas station like General Store with 80 people. That could potentially be up to $11,000 a month of increased economic into Grand Marsh. I don't know why that's being opposed, because that could be a huge benefit to our small town. I don't know where all of a sudden you'd see $11,000 a month in benefit increase into a small town suddenly. This is an older building we'd really like to see rehabbed and used for the purpose. We're surrounded by agriculture, specialty vegetables, and that's how our vegetables get harvested. Again, the crew is already in Adams County. They're just spread out in single family homes that are being taken from families that could move in or renters that can move in. We're using, it puts our county at a disadvantage to invite families. And we truly think it's a benefit, and we have, you have access to that Google Drive I've sent out earlier that has all our letters and signatures with the support. It's an overwhelming amount of support. And that's all. Thank you.
This is Larry Alsam, and my wife and my daughters and I are the owners of Alsam Farms, Inc. And we reside in Columbia County, so we're not residents of Adams County, but we are definitely taxpayers in Adams County, owning farmland and some buildings in Adams County. And we're the applicant, obviously, for this process. And I just want to speak to our intent is to be a positive influence on any community that we do business in. We operate in a town of Friesland, which is a town of 303 people. So we're used to small towns, and we also operate down by Arena, Wisconsin, and up in Grand Marsh. And those are our three areas of operation. We currently do have housing for H2A workers at both our plant in Friesland and down at Arena, and they've been successful. I live right next to two of our houses here in Friesland, and so I, as a neighbor to them, it has not been an issue at all. It's been a positive, and I live right next to our business, and so it's not like I'm afraid of living next to a house full of people, and it's been a great experience. And our intent is to be a positive for the community. We've supported the Grand Marsh Corn and Tater Festival for many, many years, for 20 plus years. We've been involved in the community that way. As Megan mentioned, we have surveyed the other business owners in Grand Marsh, and they see the economic benefit that they would probably receive from having more people in town. We recognize that 80 is it's a bigger number than maybe you would expect, but yet it would be managed well. Our intent and our commitment is that we're a positive influence in every community that we do business in, that we would maintain the property in a very positive way, that it's not going to be an eyesore, it's going to be a positive thing for the community. We've offered the village of Grand Marsh the use of the gym during the winter months. We've offered the fire department that they could use the front of the property for a landing site for any med flight type needs that they might have, that we would continue to contribute and work with the community in that respect. And so, our intent is to be a positive influence. There's a need for housing for workers. As Megan said, we do need a lot of workers. It's somewhat of a seasonal nature. So it's not going to be a 52 weeks a year, but it would probably be 6 months of the year potentially that this would happen. But we'll maintain the property all 12 months of the year, and we'll make sure that it's well taken care of. It would be on the tax rolls for the county. And so it would be an economic benefit to the county that way, and likewise to the school district and to the township. And so our intent is to be a positive influence for everybody that's on this call. So thank you for your time and consideration.
Barb, you're muted.
Is there anyone else in the public that would like to speak?
I would like to speak. My name is Luann Powers. Can you hear me?
Yes, we can.
Okay. I do have a voice disorder, so it's tough for me to be loud enough sometimes. My question is, this letter is the first I've even heard of all this going on, a letter in the mail. And I guess I'm questioning, is the school forest involved in this?
Megan, can you
It is-
answer that?
Yes, it is not. It is just the school in that cleared area. There might be, it's hard to tell, about like 6 feet into the very little feet into the trees, but just that school property there.
So I would still be able to hike back there and take my grandkids back there through the school forest.
Yes.
I would assume so, yeah.
Okay, that was one of my concerns because I do that a lot. And I guess I'm listening because the last time we had something go through with a big farm, it totally became more than I was expecting with all the trucks coming through town. And the smell that came through town. So I'm listening to this, hoping that this wouldn't become something more than it was explained at this time, like it did with the dairy farm.
Thank you. Thank you, Luann. Megan, did you have some? Go ahead.
Yeah, I wanted to just let you know, Leon, I live 4 miles away from Grand Marsh and local, and a lot of the employees here are local. A lot of them are retired folk that help with our harvest, but with this, a conditional use permit would limit us. And we would also, we have to be inspected by the Wisconsin Department. Oh, why am I blanking on that? Of Workforce Development. But we are inspected, and it's a very regulated thing that we have to abide by, very many rules, quite a thick packet. And that's why I don't think it'd be something that would come out. We can't have our crews, we use RH2A, they don't have their own cars. It's not going to become a parking lot. They use buses. I could definitely see one of our US crew leaders having a car there a time or two, but we meant to be clean. These gentlemen that come work 12 hours a day, they want to have a comfortable place to live and not have an hour to an hour and a half commute to get to the farm by 7 a.m. and leave by 7 p.m. after a long day of work. And we want to provide them with closer housing that's more convenient for all the area farmers. It wouldn't just be us using it. We would definitely open it up to other farmers if their contractor agrees to everything that we would require of it, like quiet hours, no drinking, no drugs, all of that.
Okay. And are they, when will they live there, year round or just during season?
Our seasonal workers can be here as early as April 1st, and we typically use them through the end of October. If we have a really, really warm fall, it could be into November, but it's all weather dependent. So if it's cold April, they don't come in till later. So that's our typical dates. I don't know if a Christmas tree farmer would ask to house a small crew there into November, December, but I couldn't imagine that would be a full capacity. But our intent is for our seasonal workers to have a place to live and open up the rest of the residential housing we're currently using.
Okay, thank you.
You're welcome.
Is there any other? Thank you, Luann. Is there anyone else that would like to speak? Is there anyone else that would like to speak?
This is Wendy Logic. I have one more question.
All right.
I was wondering, does Elsom Farms have a seasonal labor housing in Brooks?
No, we do not.
Do not.
Okay. Okay, thank you.
Are there any more that would like to speak?
Barb, were you saying public or everybody? This is
Anybody
Jo-
that has a question, we want to clarify and clear up everything.
Okay, so I feel like I'm beating a dead horse, but everyone that's spoken is making it sound as though the rezone occurred. And they're stating the positive. My understanding, yet again, and I just want this re-verified, the rezone did not occur, correct?
Correct.
Thank you.
All right. Is there anybody else? I can tell you right now what the conditions the town wanted on at their planning commission meeting, and they were approved 100%. I will tell you, they said a fence along back of property and 150 feet to the south on each end. And then they said the northeast corner to southwest corner, 47-inch high woven wire, number 2, no more than 80 people. No other housing can be constructed on that property. And they wanted to review in 3 years. No alcoholic beverages on premises, no drugs, no violence, and quiet time 10 p.m. That's what the town had on it.
I do have a question. I just want to understand. So the attorney for Adams County, Joseph, the minutes do say it was approved in November at the Planning and Zoning Committee for the zoning change. what was the action that you said changes that or cancels that out?
Sure, and that's the 59.69 chapter there, and you've got a town veto process essentially. You have a 10-day and then ultimately a 40-day.
Are there any other questions?
Barbara, would it be okay if we made a comment?
Yes.
Okay, this is Attorney Lee Teroni again. Just to be clear, it is our opinion that the zoning change happened. And I outlined how that is. It's pursuant to the statute and it's confirmed by the case law. The county is saying it didn't happen, but just to be very clear, we are definitely saying the opposite, that it did happen because that's the statute and the case law. I've heard no basis for the opinion otherwise. But I guess you're being invited to vote on the conditional use permit as it is. The Corp Council seems to be inviting litigation to settle this. We're not seeking litigation to settle this issue with the county. We would just like to have this a fair decision. I've never seen a hearing held where the advice was given that they shouldn't be having a hearing. If I'm hearing that correctly, I don't understand that at all. But according to us, the zoning change did happen, so this would be a legitimate hearing. And we would like to have the bodies vote on the CUP. Thank you.
Committee, do you have anything to add?
Excuse me, Barb, this is Chuck Quick.
All right, Chuck, go ahead.
I am concerned about this being said two different ways by two different attorneys. I think that the legal process ought to be agreed upon prior to the county making any vote or making any decisions on this. I think the attorneys need to get this settled and then bring it back as either 100% passed the planning and zoning, or if it has not passed planning and zoning. Thank you.
Do you choose to make that a motion, Chuck?
Yes, I will make that a motion.
All right, we would need a second on that.
Your motion is to table? Is that what he's saying?
I think he's saying to table it and let the attorneys figure out one way or the other because they're conflicting.
I'd second that.
Okay, committee, all in favor? Aye.
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 Opposed?
Aye.
Aye.
All right,
Aye.
Randy's opposing. All right, we better do a roll call vote, Dusty.
Yep. Shapey.
Okay. Bruce, your vote, please.
Aye.
Jody, your vote?
Nay.
Mine is yes. Larry,
Nay.
Rocky,
Yes.
Chuck,
Yes.
Randy,
Nay.
3 noes, 4 yeses. So we're going to table it again until we can come up with a clear thing on advice from the attorneys. That will end the public hearing then? All right, we'll
Yes.
go on. Okay, we'll go on to the financial report.
The one that was attached to the application or the agenda was the end of the year numbers. We ended up approximately about $78,000 over in revenue this year. As I've been saying the entire year, it was busy and a lot busier than we expected. Overall, the numbers, we had budgeted to be $156,000 on the tax levy. Our department, instead of 156,000, ended up being 11,000 on the levy. Due to revenue and increased revenue and decreased expenses. So that was a good thing.
Yes, it was. You want to go right into the permit report?
Sure. This is for the month of January of this year. And it's very early, but the numbers I see were not updated. That should be 2022 and 2021. But we are roughly right on par, a little ahead.
Mm-hmm.
Like I said, it's any one given month is hard to judge anything on, but based on office traffic, we are going to have another busy year, and from what I've heard from people.
Okay, thank you, Dusty. Now, planning and zoning updates.
All right. So we did hire a new administrative assistant. She does not have a camera on her computer, but if she wants to walk in here quick, I can introduce you guys. Hopefully she's listening. Oh. Considering she was taking the minutes. This is Lauren. This is the board. You'll see her. She did replace Hannah, and hopefully everybody enjoys talking to her when they call. And if you have any questions, certainly call her, me, anybody in our office. Okay.
Thank you, Lauren.
I'll give her a second to get back. Okay. Beyond that, the other item that we did start talking about a few months ago was about fixing the shoreline zoning maps and the Conservancy District. I was able to finally locate how that Conservancy District was created. Back in 1971 is the first time I saw it show up. And the definition at that time was any areas that were mapped as wetland. Later on, that's when the DNR required that there be a shoreline wetland district, which is supposed to be mapped as any area that is mapped as wetland, which rendered the Conservancy District not completely pointless, but it was very duplicative. The original mapping for that did include the upland areas in between wetlands, whereas the wetland mapping now does not include the upland areas. It's strictly for wetlands, which I believe is the intent of the shoreline wetland district. I have started working on revising the shoreland ordinance. A lot of it is cleaning up language. There's some new state laws that have to be incorporated in. The big thing on there that I did do, at least in the draft or not in the draft, what I'm working on. But I kind of wanted to get the committee's feeling. Sam and I are still working on fixing those maps. Because of the wetland district, I guess I would propose to remove the Conservancy District or delete it. And anything that is mapped as wetland gets mapped as a shoreline wetland district. And essentially nothing can happen there, which is kind of similar to what the Conservancy District is. A lot of the areas that are mapped as Conservancy are outside of the shoreline areas anyway. Those are automatically fixed because they can't apply beyond the shoreland areas. And essentially everything that we would go through a pretty comprehensive rezoning. where we would, any properties that do not fall under the shoreline wetland district would be reverted to the recreational residential district, would be my proposal. But I guess I wanted to get the committee's feelings on that.
This is Jody. May I ask a question?
Yes, go ahead.
Dustin, there's Upland Conservancy. If you get rid of Conservancy right off, you know, every Conservancy, would that get rid of Upland Conservancy?
No, Upland Conservancy is a district within the comprehensive zoning ordinance. All I'm referring to is the shoreline zoning ordinance, which currently only has recreational residential district, general purpose, recreational residential conservant, basically a planned development type thing. Conservancy and wetland. Those are the only districts in shoreline zoning. So we're not touching the comprehensive zoning ordinance or any of those overlay districts or anything like that.
Thank you.
So can you have something and put on the agenda next month about eliminating the Conservancy district then? We can't vote on it at this meeting because we don't have it on the agenda.
Correct. And I'm not looking for a vote. I guess I was just the committee's thoughts. I mean,
Okay.
if anybody has strong feelings, I can kind of start heading that direction. If the committee is okay with me bringing a draft to the board, we could actually hold a public, or at least the initial, maybe we don't do the public hearing this coming month. But I do have a draft ready. And the committee can look at that and see what they think. And without having the public hearing, we can't actually vote on it, or sorry, you guys, the committee can't vote on it, but you could give direction as far as if you're happy with the direction it's going. And then we would make it more official the following month. So we'd be looking at April.
What's the committee's feelings on that? To me, it sounds all right to bring it next month.
Can I ask another question, Barb, in regards to that before we finalize what do we think? On the remapping of the shoreland, Dustin, are you going against revised floodplain things? So you get rid of the Conservancy, now you're basing what? I mean, you look out there and you've got pinks and purples and whatnot for the width of those overlays. Are you going back to revised floodplain advice? However you would quantify that, I don't know.
Sure, floodplain. This is going to be it's going to sound like the dumbest comment you ever heard me make. Floodplain and shoreline have nothing to do with each other. Unfortunately, on our mapping on the website, areas that were mapped as floodplain, which is a completely different ordinance, did find their way into the shoreland ordinance incorrectly. Or sorry, not in the ordinance, in what you see on the GIS maps. I believe we can thank North Central or the Regional Planning Commission for that error, and then it got transferred onto our system. But floodway, flood fringe, floodplain are not districts in the shoreline zoning ordinance. That is a completely separate ordinance regulating that, which is not being touched.
Okay, thank you. Anybody else have any comment?
Yeah, Randy here. I've wanted to get this cleaned up since the day I got on this board. It has just been a bugaboo since the start. These were done with a crayon way back and colored pencil back in 78, 79. One side of the creek, it'll be 50 feet. The other side of the creek, 300 feet. So I'm all for Dusty getting this cleaned up.
Larry here. I agree. Needs to be cleaned up.
So it sounds like you should bring it back to the next meeting and we'll go through it and then we can do a public hearing in April then.
Perfect. And when I put out the agenda, there will be a link to there will also be a link to the ordinance so you can see it, well before the meeting. Like I said, it's already written, so.
All right. Anybody else have any comments? Okay. Get back
That's all I
over.
have.
Do we have any correspondence?
Nope.
Okay, the next meeting date will be March 2nd at 3:00 PM, 1 month from today. And I will say the meeting's adjourned.
Thank you all. See you later.
Thank you. Thank you, everybody.
All right, thank you, Bob.
Thanks, Barb.